And I'm quite keen to just talk about the assessment at the start. That seems to be the bulk of the emails that I've been receiving about the subject, so we're going to go over that. So the first things first, groups. Start with groups. This is the easy bit. We can resolve this pretty easily. Only one group has sent me an email. And in class, oh, yes. Last week? Okay. I will put you in a group at the end of this session today as well. What I would like is for the group, basically I just need a list of names for each of the groups. I have all of the emails for everybody, but I don't know what the compilation or collection of groups you guys have come up with. In terms of the people that's in your group, I need to have an email that I've been CC'd to in order for me really to be able to give you guys structured feedback. The idea is that the people that were here last week, you guys have been put into groups, and the external students that collectively form one group, and some of the external students that actually come to the internal classes have been put into these groups as well. But I've only had an email, a CC'd email with a list of names from one group so far. So if you're in a group, I wholeheartedly recommend that you send me an email, because I'd just like to start really opening those lines of communications to that. Now, you guys appreciate that first task, your feed forward date is this time next week. What does that mean? That is the time where if you submit before 6 p.m, I will give you structured feedback. Essentially, I will mark your work, tell you where you went wrong, and tell you what you have to do in order to get a much better grade. This is a very valuable thing. So while strictly speaking, all 5 of your pieces of individual assessment are not due until next May, I think it is. I think this is the middle of May, I think 16th of May. Yeah. Strictly speaking, they're not due till then, but you'd be crazy to not, wherever possible, take advantage of the feed forward time. Now, with the group tasks, again, they're actually not due until the end of exam. You can leave them, you can do them whatever you like. However, you might notice that the group task will help your individual task quite a lot. And the process of doing this is by design. If you guys function well and cohesively as a group, smash out the group assignment, send that in for feedback. Whenever you send those things in, I'll try and get feedback within a few days. Back to you guys with that. And you'd be crazy to not take advantage of that, I really think, because the feedback from the group assessment can go to everyone in the group, which can be things like, oh, hey, in the case of this first assignment, you need to find primary sources. You need to actually find the place in the Federal Court Act or in the Queensland Civil and Administrative Tribunals Act 2009, where it actually says there is a fee, it is this much. Or there is fees are prescribed in regulation, this is the regulation, the amount is this much. These are the bits of information that you guys are going to have to supply as part of your task. It's not sufficient to go to the website, get a piece of information and relay that back to me. I need to know where it came from. And that's a core task of, well, it's a core task of legal professionals, but for you guys in terms of business professionals, it's a core task of reading statutes and doing sufficient research in order to come up with a real justification for what it is that what you're trying to say and trying to assert. Okay, that's the first thing. The second thing, the reflection piece. Now, I mentioned in the first week that the reflection piece is double chance. So that if you've submitted it into LearnJCU in the Dropbox by now, good work. I will go give you a grade, get you back some feedback from that. If you haven't, that's okay. You actually have until the end of semester, but there is a big but, big but associated with that, which is if you do wish to do the double chance with the reflective piece, you're going to have to talk about the law as part, essentially as a third framework. We had the 2 frameworks for the reflective piece, and I suggested about 500 words. So if you do want to resubmit, you're more than welcome to do that, and your grade can only go up. Your grade can only go up. There's no harm in that, and you have until the end of the semester. And look, to be honest, because you're going to have to talk about the law, you're probably not going to be able to resubmit for a little while, because we're going to be learning the rules of contract over the next sort of 5 or 6 weeks. So, and don't stress about it. You can resubmit that again up until the end of the exam period. The deadlines for the subject are actually quite fluid. And look, this is kind of a little bit more like real life. Most of you guys in your education system, you have deadlines. They are very, very firm. With this is a master's level subject. It's up to you guys to really manage your own learning. If you can know the stuff and you can demonstrate to me that you know the stuff, that's great. I'll sign you off very happily for a pass for the subject, or a good grade, or whatever you need in terms of the quality of what you produce. Okay, and now I know it's a little bit nerve-wracking with some of these things. You know, we're 20 odd people in the room, but does anyone have questions in relation to that assessment before we move on? Yes.
Just on the format of the structure, how we write it,
Mm-hmm.
follow the normal essay structure?
No, for the reflect. Oh, so we're talking about for the assignments. Okay. The way I suggest that you do these is that there's essentially it's split up into 3 questions, and you'll read about in the Learn JCU. It has an example of this IRAC method. We're explaining the issue, finding the appropriate legal rule, and then applying it. I think it's probably even a more condensed version of that. The issue is you need to find which is the appropriate court. That's the first part. You need to say the appropriate courts are if the matter is less than $150,000, the Magistrates Court Act. The Magistrates Court has power or jurisdiction to hear that matter. Again, in a certain section in that particular piece of legislation. If it's under $25,000, the Queensland Civil and Administrative Tribunals Act suggests that you can states that it has jurisdiction to hear matters involving traders. But again, you're going to have to go through that act to find out whether or not the definition of trader is going to work. Yeah, definition of traders. You have to actually go through and read that act. And you can state those rules and principles in a very basic sense. State all of those rules and then apply them to your facts that you've got there. So you have 3 scenarios, and for each of those you could say this one is federal law because it's to do with trademarks, section 51 of the Constitution, sub 51, don't quote me on that, 16? Not sure, actually not, I'd have to go back and check. The Australian Constitution says intellectual property is done by the federal government. The federal court has jurisdiction to deal with that. And, yep, I'm just going to shut the door. The Supreme Court has unlimited jurisdiction to hear all matters of Queensland law. Trademarks, though, trademarks, defence, banking, external affairs, certain aspects of Australia are exclusively the domain of the federal parliament for legislating, and intellectual property is one of those. It's one thing you guys, there's a given for your assignment. When you're doing your assignment, there's a question about trademarks. It's while strictly speaking you can go to the Supreme Court, you normally go to the federal court for those matters, to hear those matters. Yeah, because the federal courts have jurisdiction to hear federal matters. And there is also a section on alternative dispute resolution. Now, unfortunately, I've only did 1 slide last week, but it is a big part of professional practice. That generally when you have a matter and you go and apply to the courts themselves, the court registries will actually say, before we go to court, you have to do mediation first. It's a very common step. As you probably, if you guys have actually done any research, actually calling up the registry and talking to them, as some of you guys have, they may mention that hey, when you go through and do these things, you've got to do mediation. It's a step. The registrar, and again, I'm quite curious to hear what your thoughts are dealing with the court registrar staff. They have discretion. They are the ones that actually determine things, whether or not we have to do mediation or don't. But again, you have to find those particular rules in the various acts that give them power to do that. It's a research task, but the key thing to note, it's to do with jurisdiction. Who can hear this matter? Because if a court can hear a matter, a court has the power to grant an order. And a court order it's essentially this a representation of just raw power. The executive arm of government is obliged to carry that out. You get a court order that says this person is to pay you. In fact, I have a dividing fence issue myself at the moment, and there is a court order in place, strictly speaking it's a tribunal order, but we won't split hairs, that says the 5 parties are to pay us. If they don't pay us, I can ask the court to do things like take the money straight from their bank account. arrive at their property, if they don't have money in a bank account, take their stuff and sell it. Garnish their wages. You guys have heard garnish? Garnish is when you take a fraction of somebody's wage if they have a POE type job. Or otherwise recover assets from that particular person. That's what that is the power that a court document has, a court order has. Okay. Any other questions for that assessment task? Like I said, remember they're not strictly speaking due until May, but you look, because only the best 3 of your 5 count. Give it a go. Just hit something up, give it a go. I'll give you guys feedback, particularly for the first assessment. It's really important for you guys to have structured feedback in terms of how you're going with stuff, particularly writing. One of the difficulties with this subject, where you've got a lot of sort of English, not necessarily English as a first language people, it's very important to identify early in the semester if you need additional writing support, because JCU supplies this. They have professional staff that will actually help you write your assignments. And so I can go and guide you guys if you're struggling, particularly in the first few weeks, towards that, to go and to do that. And like I said, there's no one in this class who came to all of the lectures, went through, did all the assessments, hit the feed forward. No one even got close to failing the subject last year. Appreciate it is quite a lot of work. And that was the other bit of feedback that I've had so far. It does seem like a lot of work, and it's a master's level subject. But no, your best 3 count. Yep.
Our group has done about
Yep. Yep.
but it is a lot more over
500 words.
500.
Okay, well that's fine. So
Is that okay?
yeah, that's fine. We'll submit it, and again, I'll provide that feedback. Again, it's the target amount. This is an MBA subject. There's no strict word limits as such. That's a target amount in terms of the information that you have. Yeah, I'll be clear. If there are bits that are irrelevant, I'll just go through and just say this is irrelevant in terms of that, and that can reduce the overall quality. But it's difficult. Look, to be honest, with the group task, because it's satisfactory, not pass. It's not really pass fail, because you get a chance to resubmit it. You fail if you haven't done it by the end of the exams, but that's pretty extreme. And it's pretty hard if you put extra words in for me to fail if you've talked too much about a subject, to be honest, in relation to that. But the target is about 500, because your other assessment is about proportionate as well. I think it's three questions for 1,500 words, whereas the other one is 1 question for 500 words, I think. That's the way it's structured, something like that. Okay. Any other questions on assessment? And like all of these things, come and see me. I've had 4 or 5 students already come to see me. That's really good. It's really good. It's a very, very positive thing. One of the big advantages of having an internal subject is the staff are here. You can just walk in, usually book a time, but for me, you can usually just walk in because I'm usually free. Walk in, hey, I've got a problem. Okay, let's talk about it. I think it's a very, very useful thing, and it's something, again, different education styles and different systems. When I was 18 starting university the first time, I was way too scared. I was way too scared of just wandering into the lecturer's room, and with a few more wrinkles and, well, a lot less hair, that fear goes away. And you guys, we're all well into adulthood. You shouldn't have that fear to go through and do that. So just literally knock on my door. I'm here to help you guys learn. That's my job. All right. Now we're going to move on to contract law. And I'm going to kind of apologize for this next few minutes. I have a very specific echo hearing myself talk when we're going to be talking about contract, because contract law is huge. And sometimes I say with these classes, oh, we're going to finish early, we should finish early. This one probably won't. There's a reason for that, is that I'm just going to go through quite a long story about how this came to be. And so if you're on sleeping meds, make sure your head's near some sort of pillow of some sort, because without really understanding how contract came to be, the point gets lost. The point gets lost in this. And so really contract law, it's going to sound a little strange, but I'm going to go back and tell you a little bit about global history. Feel free to interrupt and interject in any way, shape or form, but we're going to talk a little bit about global history. So, and again, my somewhat humble knowledge of anthropology, Homo sapien moved from Homo erectus and left Africa. I think it's the commonly accepted scientific consensus there is that human beings came from Africa and went wandering around the world in various places and formed. Originally, humans, of course, were hunters. Human beings, look, we picked up. Has anybody watched 2001: Space Odyssey? The movie where they touch the thing and then they can pick up the tool and whack the other monkeys. We started to pick up tools and we could control the environment with fire and tools. And human beings moved around, were nomadic, and were hunters. And again, came from Africa, although humans stayed in Africa as well. But the key change that happened with agriculture. This key change. Remember a few weeks ago I talked about agriculture in relation to civilization and British and Australia, but this key thing historically was when humans discovered that they didn't have to be hunting all the time. They could stay in one place and could put plants in and around, crops in and around rivers and have cattle. Then that really changed the way human beings lived. It changed the way from having small sort of hunter-gatherer type communities into larger communities. And the classic one, the most important one of these in the ancient world was in the Levant. Do you guys know where the Levant is? It's this what's called the Fertile Crescent between modern-day Israel and Kuwait, Iraq. So the Fertile Crescent. The reason why that was the most important one, it was the easiest. It was the easiest place for early humans to go and control the rivers in order to have crops. And as time went by, human beings got better at controlling these things. And so they talk about, and anthropologists talk about this, the great centers or cradles of civilization. And so as well as the people of the Tigris and Euphrates, which is the first one, you had also around the Nile River, you had the Ganges in the Indus Valley on the subcontinent, India and Pakistan. You had the Yangtze and Yellow River in China. You had, oddly, the anthropologist pointed this as another great cradle of civilization, actually the PNG Highlands as well. PNG Highlands count as one of the great early centers, and in Mesoamerica. I think that's all. Yeah, those things. I think those six. Mesoamerica, in the middle of America, where the Aztec Empire came a long time later. So you've got these early centers of civilization, okay, and they're all based around agriculture. And one of the things that we'll be talking about in terms of law, and because these things go back a long way. In fact, there was a Babylonian ruler called Hammurabi who codified all of the laws of Babylon. I don't know if this sounds vaguely familiar. In the Abrahamic faith, Islam, Judaism, and Christianity, that forms part of the mythos there as well. But a key thing to note that with these 6 centers of civilization, they had to have structures. Realize when human beings are together, they have to start to have rules. Those rules used to be pretty much what we would now consider to be the criminal law. If you lost the goat, the family no longer has goat, family can starve, so that the person is punished in what we would consider to be criminal law. And so we'll actually return to this in week 10 or 11, where we'll talk about bailment, why it's the oldest of things. Looking after things was important. The concept, and things like money, contracts, and deal making didn't come till a long time later. Very much these 6 centers of civilization were pretty much on their own. And they built up over time and developed all sorts of other technology. But essentially, this is a key thing to know, is that the laws in relation to these places were very much to try and keep people from dying. You've got you're right on the edge. If you get great floods or you get drought, you die. And so you appreciate that harshness comes with a lot of these things. And so a lot of these things we come when we talk about in terms of law comes from this really harsh sort of backdrop or background to these things. So human beings from these 6 great centers spread out. And so when we think about this these days, go back about sort of 2,000 to 3,000 years, the great civilizations that you hear about, the Egyptians, the Babylonians, the various Indian civilizations, and in China. Okay, those are, and also the Central Americans. They come back to the story a little bit later, but you appreciate in the New World they were quite cut off from the others. There was no connection between the Americas and what we call the Old World. So I'll call it, it's what we refer to there, the Old World and the New. And it's actually important in terms of global history. So you've got these centers of civilization, and they're starting to expand. And particularly, things happen, particularly a lot in the Middle East. Again, it was the first place, the Levant was the first place where humans started to have agriculture. And what you find is that when people trade, most of you guys have an economics background, or at least you understand or appreciate this stuff. If I have some excess grain and you have some excess cattle, we trade. And in theory, both sides are better off. Because if we didn't trade, again, we would only come into this, do this trade, if we, with our own self-interest, would become better off in doing this. And so these systems of trade ended up being very, very important. Because if you have things, and not just physical things, knowledge. When writing started to be a thing, this ability to trade information and to trade refined things. Because you couldn't really have, when you're living very, very close to the edge, very, very hard to have craftspeople and poets and philosophers. You couldn't really fund those sorts of people. Everybody has to go on the farms. But as civilizations started to get wealthier, they started to actually have a bit more time to do things, to actually go and create works of art and to create mechanical things and to actually do that. And part of that, again, forms part of these trade networks. Now, again, a lot of this is centered around the Middle East. Europe came later. You appreciate, going back to those 6 centers of civilization, we think of a lot of the last probably 500 years has been very Eurocentric, for want of a better word. The various European nations and people, through the process of colonialization, have a disproportionately large amount of their culture influences the world, language and so on. And there's a very particular reason for that. And the reason for that came from a business problem. Because, it's kind of funny now we think about the Chinese economic miracle, the economic might, the manufacturing might of things being built of high quality for low cost in China. But the Chinese have been building manufactured goods of high quality for a really long time. Really, really, really long time. And so if you read a bit of history about this, you go 2,000 years, people in and around the Mediterranean, the Greeks, the Phoenicians, and then later the Romans, they wanted Chinese goods. Chinese, really interesting, high-quality Chinese goods have been desirable for a very long time. Okay, and getting goods from China was really hard. What do you have to do? You have to go by land all the way from the coast of the east coast of the Mediterranean, all the way through Central Asia, all the way through these highlands. Very, very long journey to get all the way to the great centers of manufacturing. Okay, again, going back 2,000 years. That's how that happened. And you guys have probably heard of the Greeks. Greeks had a civilization and they conquered. A guy called Alexander the Great conquered all the way up to the Indus Valley, and then they convinced him that there was nothing important any further, so he turned around and went back again. And later on, the Romans looked at what the Greeks did and thought, we can do better than this. The Romans didn't actually add much in terms of philosophy and art and so on like that. They basically did what the Greeks did, but did it better. And the key thing about the Romans is they were really, really good at warfare. And so the Romans developed their system. You guys know what I mean. Rome, the city of Rome in Italy, they had an empire in and around the Mediterranean. It spread all the way through to modern-day Iran, all of North Africa, all the way through to modern-day Russia and so on, and Britain as well. So Rome, or the Romans, conquered. The reason they could conquer, they mastered the art of warfare in the ancient world. Anyone know much about Roman warfare? They had these big tower shields, and they had reasonably well-made iron weapons. And they worked out in systems of warfare that when the barbarians, and when I say barbarians, I mean all non-Roman people, were charging at them or shooting them at arrows. They had tower shields, so they didn't have to worry about the arrows, and they had systems of drill. They pushed the shield in front and they stabbed the guy to the right. That was literally how they did it. And this worked really well for them for a very long time. Now, we hear about this rise and fall of civilizations and empires. The Roman Empire, they had amazing infantry. Not really so good cavalry, not really so good boats, but they had good swords and shields, and they had good siege weapons. That was pretty much all they had. The other thing they had was this system of government. All right, their system of government that they set up. When we talk about Roman laws, they would go to a place and wouldn't automatically just try and kill everybody and take the land. That wasn't really how the Romans worked. They would go to a place and they had a powerful culture. They would try to encourage people to become like us and set up systems. And you appreciate that the Romans were very good at making roads, very good at making aqueducts. They were good at building and doing stuff. But the real problem, the fundamental problem with the Roman Empire, what was their source of energy? What was their source of labor? Slavery. That was how the Roman Empire, in terms of doing stuff, getting stuff done, was what it was founded on. They would go to a place, take slaves, get the slaves to build the roads. Romans were still the ones that coordinated it, designed it, did all of the brainy stuff. But fundamentally, the slaves did the work, and it's kind of strange when I say this, particularly the Australians. The citizens of Rome were essentially all on the dole. They would have the grain would come in, and they didn't have to do anything. The fact that they were Roman citizens was all. That was how that worked. Now, the thing is with having an empire that's run by slaves, that works fine, I suppose. Not great if you're a slave, of course, but perfectly fine if you're a Roman citizen. And that system can keep working, and it can keep working provided that you continuously have a really awesome army and you can continuously keep taking slaves. You can guess where this story's heading, can't you? So after the Romans converted from their sort of pagan polytheistic gods to Christianity, they weren't quite so good at fighting. And so what you found is that from about the 1st century AD onwards, the Romans started to reach this point. Their empire had got too big and they weren't quite so good at defending it. And you start to see this point where the empire starts to sort of shift and retract, and people start revolting against it, and the will to fight starts to go. And because it turns out fundamentally, this is the fundamental point, if somebody is pointing a gun, or in that case a spear, at your head and tells you to work, all right, would you work? Yeah, probably. If the spear is taken away, would you keep working? Probably not. Probably not. I'd probably run away to Germany, whatever they did. And really that's this key thing. There's no incentive for the labor force to keep working when the Romans could no longer, essentially through might, enforce their empire. Okay. And so that meant that the various trade groups and networks started to diminish, and the Roman Empire split up into a whole variety of different things. And by I don't know if you're aware of this, the Roman Empire was split to two halves. The western side sort of really got sacked in about 400 AD, whereas the eastern side hung around for a long, long, long time. It was called the Byzantines. They hung around in Constantinople, which is modern-day Istanbul, which is the center of essentially the center of Christianity, was modern-day Istanbul. That fell to the Turks in about 1452, plus or minus. Why am I telling you all this? Well, when Europe had, at this stage, through the Romans, had a lot of money, a lot of stuff. came into it. A lot of infrastructure. Stuff was on the up. When it was on the decline, stuff started to not be being built, and stuff started to fall into decline. And you find that other civilizations would come along. The main one, Islam. And so I think Muhammad was around about the 6th or 7th century, but it was really about 900 or 900-ish AD started to conquer. A religion that set about conquering went to the Indian subcontinent, did a lot of conquering, went all the way through North Africa, all the way to Spain, and conquered. They didn't make it to France. The French, Frankish knights sort of stopped at that particular point. But the key thing to note about all of this, in that the various bits of the Roman Empire splintered into essentially little city-states. So Italy itself would have Venice, Naples, Genoa, all these little city-states. And if anybody here had to study Shakespeare, has anyone had to study Shakespeare at school? I don't know if you guys do, but if you have to study, if you study in Australia, from in a high school level, you have to learn these because it's quite centric to the English, the way the British think, which is a bit scary. But all of these little city-states no longer could go to China because the Turks had no love of the people of Western Europe. And so this ancient road of trading between the Mediterranean and China and Japan was closed. They called it the Silk Road. And the Silk Road was closed. And when the Silk Road was closed, that left all of these little city-states in Europe with a bit of a problem. And I like to think of it in terms of you guys, it's a business problem. Because if we get stuff from China and we get it all the way back to Portugal or to Spain or to any of the Italian city-states, we make a mint. Because those goods, those beautiful, well-crafted, manufactured Chinese goods, and appreciate the Qing or the Ming Dynasty was at its peak as well in China at that stage too. It was one of the points and the high points in civilization in what's now modern day China. We can get their stuff. We're going to make a mint. How do we get it? Well, the devil's in that detail, isn't it? And so they started to have boats, or try and build boats that would go all the way from Spain and Portugal, all the way down the coast of Africa, all the way to the bottom of the Horn, all the way up past what's Zanzibar, now Tanzania, and you've got to worry about pirates, the coast of Namibia, you've got the Skeleton Coast, you come to the Horn of Africa, all of the Arabian rulers were quite happy to take taxes or to just take whatever. You've got pirates everywhere. You come out to the Arabian Sea, you then come to the Indian subcontinent, come to Mumbai, come all the way to Ceylon. This is a huge journey. You've got to go most of the way around the world in order to get stuff from China. But they did it. And they did it, and they tried to do it to make it profitable. And it was hard, it was arduous. And they did it to some extent. But it was so risky. You know, what's the thing? Accounting students, when things are high risk, they have to be high return. And those things were balanced out because it was such a risky thing. And anyway, some bright spark thought, well, why don't we go the other way? Sorry, what other way? Yeah, why don't we go the other way? Why don't we just go across the ocean? And they tried to work out, because appreciate this idea that the Earth was flat. There were people in the ancient world. It's absolutely, completely not grounded in history. It's completely false. You can literally go back to the ancient astronomers in India, in China, and in Greece. They all knew the Earth was round. This was a myth. This was just literally a history myth. My ex-wife teaches history here too, and it's one she raves about. It's completely made up. They knew the Earth was round, but you're still having to convince a bunch of sailors to go across the ocean to try and do that. And so in the year 1492, a guy called Christopher Columbus managed to get some money together, managed to get 3 boats, and went west. Why? Trying to solve a business problem. Okay? So they've gone west. They've discovered a bunch of islands. They think they're in the Philippines, by the way. They knew the Earth was round, but they didn't do their numbers very well. So that's why it was called the Indies. Of course, it's the East it's, well, the West, I suppose, the West Indies. This is the India. This is part of India. Surely it is. And that's why you get this term Indians. Usually it's used as Persian these days, but that is why that term is used in North America and the Caribbean, because they were mistaken. They were just mistaken. They thought they were in the Philippines, but they were not. And it took them a while to work this out. You appreciate a decade or so went by before they said the Portuguese and the Spanish worked out, oh wow, there's a whole new place here. Oh wow, there's people here, and these people have gold. They have gold, but they have Stone Age weaponry. So you just imagine that, you go back 500 years, and this is a long time before we had, the United Nations and concept of human rights. So you have got these very religiously fervent types that are like, wow, we can go to this place. We can take horses, we can take guns, we can take steel, we can take our fancy boats, and we can dominate. And that is what they did. So the Spanish, the term conquistador is the Spanish word for the conquerors. And so they would go with very small quantities of people and just completely wipe out, conquer, enslave peoples of the Caribbean and of Central America and of South America. Okay, to a lesser extent North America, that's a little bit later. But this key process was, armed with all of the indicia of contemporary civilization, again in the 15th century, you can wipe them out. And there was one other thing that they had that the locals didn't: resistance to germs. And so 95% of the people of the New World just got killed through the result of all of these things. Yeah, there was a little bit from warfare, but as a percentage, germs killed way more. Way more. So, again, incentives. Keep thinking about this in terms of incentives, because when the Spanish arrived, they were the first ones. They were the bigwigs. The Spanish and the Portuguese arrived. They got to set up things a long time before other powers realized all about this new world to be pillaged, to be plundered, to be profited from. And so they literally came, took a bunch of gold, but what they realized after doing that for a little bit, the people are all dying. Yeah, we can enslave them a little bit, but after a while, you've done that, you've taken all the gold, okay, then what? Well, what's even more profitable? Do you know what the tropics has a lot of, as we well know living here? Sunshine. What does Europe not have quite as much of? The same quantity, the same thing. And so what they realized is that some of these crops from the New World, and some from the Old World too, rice being the main one, would grow really well. Grow really, really well there. So sugar, which is actually an Old World food, and rice, and later on tobacco and coffee, all of these crops that we have, and sugar being the main one, sugar being very, very, very lucrative. It's something that was very, sugar was literally on par with gold if you went back 500 years. We think of it now as like $1 a kilo or something along those lines, but you appreciate how powerful the effect that would have had on people that had never had it before. It's just pure sugar. Oh, it's the best thing ever. And so the way the trade winds work, though, the prevailing wind goes from Europe to Africa, Africa across to the Caribbean, and the Caribbean back to Europe. This triangle, and this triangle of misery. Because what they would do is take manufactured goods from Europe, go to Africa, trade them for slaves. Take slaves across from Africa to the Caribbean, and then take the product of labor, slave labor, back to Europe, and repeat that process. And so that process of human misery carried on for, again, originally by the Spanish and Portuguese, later by the Dutch, the French, and the British. And that cycle of misery carried on for many, many years. In fact, some of the cases I think we do for this class go all the way to the 1800s in terms of those stuff. So that's something in terms of the way that worked. It's to do with incentives. They had an incentive to make profit, and they did. Okay, now that sounds somewhat miserable in terms of a quick thing in global history. Well, again, this is here we're doing English law. in British law. So what specifically? How did they specifically get involved? And I think more importantly, how did Britain, being a tiny little island that was a very late player in this, manage to take over the other ones? How did this actually happen? How did the Spanish and the Portuguese lose out in all of this? And the key thing goes back to incentives. Remember I talked about the Roman Empire? You take slaves, and that's fine. While you're holding the spear to their head, they'll work. Maybe not work the best, but they'll work for you. Maybe not enjoy it, they'll do it. And the Spanish and the Portuguese had a very similar model to this. If we have slaves, they'll work, and while we can still control that. What happens when you can't control it? Not going to work for you anymore. And so one thing that happened, and again, the various European powers fought a lot over the various things in the New World. Because as you could imagine, in a simpler sense, doing this trade thing was a horrible cycle of human misery, but it was very, very profitable. It was making these European powers rich. And what do they do with these armed riches? What do European people do with newfound technology and wealth? Well, they go to war. Of course they do. That's just what they've been doing for thousands of years. And they did. And they would fight these series of wars with each other. And by and large, the Spanish and the Portuguese were the bigwigs at the start. What happened, though, later on, the French started to develop their own colonies, and later the British did as well. But this was all tempered by the fact they're all, as well as having their various colonial powers, they're also having to fight wars in Europe. These countries are right next to each other. Literally, you can have all of these colonial things doing this, that, and the other thing. But at the end of the day, if the Spanish have just taken Paris, well, you're lost. And so you've still got all of these battles that are going on throughout Europe in that time. And I mentioned last week or the week before about the Treaty of Westphalia in the 1600s. By the 1600s, the Spanish were definitely on some sort of decline. They were still the biggest power, but you could see that in terms of their business model, the Dutch and their techniques of doing business, a bit grotty, but you guys are aware that the VOC, you guys know what the VOC is? It's the Dutch East India Company. It's the first great corporation. It's a company established by charter. We think of it in terms of corporations, that we go and can just fill in a form and create one. But back in the day, that had to be done specifically. And the Dutch, their model was starting to chip away at the Spanish. And later on, he said the French as well. Now, the British were broke. British in the 1600s, they decided after fighting everyone else that they'd just pause fighting everyone else, and they decided to have their own little civil war. So they weren't party to this Treaty of Westphalia that I mentioned in the 1600s. And by the end of that, and I think I'd mentioned this, Cromwell won, Parliament won, and we had to restore the old king, or the son of the king, to power in the late 1600s. Now, England, though, this is before it was Britain, England's still broke. They've got no money. They're losing money hand over fist in their colonies. They're broke. They've just fought a civil war. One thing happened, and the historians point to one particular event that happened during the reigns of James, who was, in all accounts, a terrible ruler. One thing that he did in the late 1600s was to create a thing, quite a novel thing, called the Bank of England. Now, strictly speaking, it's not the first central bank. The Swedes had one as well. But the British one had, or the English one, had a very specific objective and goal. And that was to allow people, not just wealthy people, ordinary people, to be able to come, give the money to the bank, and receive some sort of form of interest, 5% at the end of the year. And this seems straightforward to us now in the 21st century. This was very novel at the time. So in the late 1600s, 1691-ish, they created the Bank of England. What that meant is that people, both wealthy and non-wealthy, could wander into the bank, deposit their money, and it becomes the risk of the Bank of England. So that's one thing too. It becomes a risk of the state. And the thing is about sovereign risk, of course, that if the sovereign is conquered, if England's conquered, we're all going to be dead or to whatever anyway, so it doesn't really matter. So let's just put this in the power. Bank of England, we will invest in you, and hopefully with that, we'll receive some form of benefit. So you can have tiny little people, well, it sounds bad when I say this, but lay people, ordinary people with not much money, put it in the bank, receive some form of interest. It's it seems like just so passé, but it was crazily revolutionary at the time. Because what happened? All of a sudden, the government of England now has a pot of cash. So what they were able to do is to embark. Remember, Britain, England's a maritime power. They were able to embark on a series of shipbuilding endeavours. And if we think about this, if you've got government money that's going and saying, okay, we're going to build boats here and here and here, there's a flow-on effect that comes from this. Because when you were going and saying, we're going to build a boat, what that also means is that we're going to need a whole bunch of other people to build rigging. We're going to need a bunch of people to build pins. We need people to do timber. We need people to bend timber. We need people to design these boats. We need people to do all of these things. And this wasn't government run. This is privately run. People have an incentive to put in time, to put in labour, to put in effort in order to try and supply these boats to get some of this Bank of England money. And so and what you find is, as a result, what the English found is that once they've started to build a whole bunch of boats, they're more able to protect their trade routes. And you appreciate taxation at the time. Most tax was in what we call the form of import tariffs. So you pay 50% import tariff, for example. And hilariously, the English always insisted that coffee be made up in barrels. So you had to have coffee in liquid form when it was imported, like you would do beer. Of course you would. You'd have to make it. And this is why I'm completely convinced that the British are just terrible with coffee, because they never got it. They never really understood. But with these new boats, they're able to protect their trade routes. What does that mean? More money coming to the government. So more money is able to go back to building better boats. More sophisticated boats, more technologically advanced boats. They started putting copper plating on their boats. They started developing their cannons a lot more, which means that they go from being able to protect the trade routes to be able to, and again, this is about over a 40-year period, by about 1730, are dominating the oceans. And really, that's this key thing. British got to do this largely from their banking system. That is how that came to be. And so by the mid-18th century, this is the 1700s, the British have got the largest empire across the world. And they're able to do that because they're able to protect it with the most sophisticated boats, with the most sophisticated cannons, the most sophisticated navigation systems, other things that flow from this, things like the Royal Society, paying scientists, giving scientists prizes to do things. You guys heard of the X Prize? X Prize, where they put $15 million, make a reusable rocket. And Elon Musk goes to try and make a reusable rocket. The vegans have an X Prize. Make something that uses Petri dish chicken. Tastes like chicken, but isn't chicken. Give you $10 million if you do that. These are things where you basically put these things out, say, we're going to give you this much money. So one of the examples, the British, a device for measuring longitude. Latitude you could work out from the stars, I think, but you couldn't work out where you were this way without, and so a guy won this prize. They didn't give him the money, which is a bit sad, by making essentially an indestructible clock. And this is the sort of example, though, when you've got cash, government money that's flowing back into these things, it turbocharges the economy. So the British, more able to defend their colonies and protect their trade routes, meant that their government was more able to collect tariffs, which means they could put it back into doing things. And so that's what happened in the 1700s. And so what you found, though, is that this was all fine and good. But as the empire starts to get more sophisticated, much like these earlier empires did, the Romans, the Babylonians, the Chinese, when things start to get more sophisticated, you need to have more complex rules and laws and systems to regulate this stuff. And so what they found is that the British system was very much geared around boats. Right? but that was the source of their power, and it was very much part of that. I guess the culture of these things, and so they set up and developed their court system in and around this upholding of trade, or upholding the bargain. And you will hear me refer back to this. And this whole time we're talking about contract law, what the British would do is uphold this almost sacrosanct bond between two parties coming together and exchanging of promises. And that is why it's a really core function, and unlike most of the other systems that got developed, both on the continent in France and Germany, but also in the other centers of civilization, the Mughal, the Islamic, Chinese systems don't have this almost harsh aspect that the British common law did in regards to deals, the cutting of deals, because their whole system was set up on this. The whole reason Britain got to be a power was because two people would come together. I have some chickens, you have some cash. I want chickens, you want cash. We're both better off. And you appreciate, the economist, most of us have studied economics here, that idea that if we do this many, many, many times with the lowest transaction cost possible, that means that our economy gets to grow massively. And that's really what it's about. When we talk about GDP, it's about things doing things, people exchanging promises, doing things for each other. That is fundamentally what this is about. And that is why, for a long time, the British systems of common law and the contract law rules that we'll talk about very much are geared in this idea of upholding the bargain. They will bend over backwards, as I described, in order to find that a contract exists, regardless of the fairness of it. Okay, there are things that will mitigate fairness, and again, we're going to go through and talk about the way contract law works. But I think it's important to appreciate that by the time the British reached the turn of the 19th century, so 1800, these systems that are in place, and they're very much grounded in judge-made law, the common law of Britain at that time. Okay, so that's global history in the space of however long. I probably should let you guys have a break because it's probably all. Yeah, we'll take 5 and that. But I think it's a really important thing just before we start to really appreciate why this stuff is as it is. So even though it seems like a disproportionate amount of time to hear me talk about global history, it's something just to leave on the back of your mind, because we've all, our minds are all very coloured, I feel, about the way that colonialism's worked in terms of these things. Living in a colonial country, and most of us have come and grown up in colonial or ex-colonial nations. It's important to note how and why that came to be. So anyway, it's a bit of history for you. We're going to come back after the break, after 5 minutes, and we'll talk about some actual forming of contracts. Okay? Thanks, guys. Righto. I'm going to kick this one off. Here's a contract. Oh, no. Error. That's better. Here's a contract. So, what is a contract? Contract is a meeting of minds. There's a bunch of different definitions. I'm just taking the one from Steve Brock because he taught me. And so this comes from his text, which is your text, which is essentially a contract is an exchange of promises. Contract is an exchange of promises. And the economists amongst us would have all sorts of theory as to how this is fundamentally structured in terms of human incentives of doing things. But from our perspective, I'm not too concerned about the theory. I'm not going to assess it this year. And so all we need to know here is that contract is an exchange of promises between two, sometimes more parties, but fundamentally for this course, which is going to talk about two bilateral arrangements. And the definition of contract is that it is a series of elements. Now, in law, occasionally this term comes up, and it's unfortunate because it never actually get explained to us in law school, but you'll hear the term elements and you'll hear the term limbs. All those terms mean is that a series of legal points have to be established for something to exist. That thing could be a cause of action. So, for example, to bring the cause of action of grievous bodily harm to a person, the Crown Prosecutor would have to prove beyond reasonable doubt that that defendant unlawfully caused grievous bodily harm. We say those are the three elements of that particular crime. In contract, we use the term elements to describe the 7 necessary components that all contracts have to have. And there is an acronym. I actually mentioned this to Steve, who wrote the textbook. I actually found an English word which describes all 7 of those things. The English word is comical. C-O-M-I-C-A-L. Doesn't work really well in terms of describing them because the elements are best described in order, but in theory, capacity, an offer, mutuality, intention to create legal relations, consideration, acceptance of the offer, and legality are the 7 things, legal points, that have to be proven for a contract at law to come into existence. So we say a contract is this exchange of promises. That's really an abstract thing. But in terms of law, in order to prove that a contract exists, we need to demonstrate that all 7 of those things are there. All right, I'll come back to this in a few minutes. And I'll just note that this is really in relation to this aspect of this subject, because today, the remainder of this thing, we're going to be talking about contract formation. What is a contract? How are they put together? Right, that's today. Next week, we're going to be talking about terms. Terms are describing what is the contract. What do these promises actually entail? All right. So this week is about coming together. Do we have a contract? Can we form one? Next week, we're going to be talking about assuming that we do have a valid contract. What does that mean? What does that actually entail? What are the promises and how do we interpret those? How do we read, if it's written, a contract? The week after that, we're going to be talking about what we refer to as vitiating factors. What things can render a contract invalid in some way? Contracts that come together can have all of those 7 elements, but they can still have some form of legal defect. And the reason why we study that over an entire week, an entire 3-hour lecture, is because there are lots of ways contracts can be defective. And often, they're the things that you really care about because that's the way you can use to try and get out of a contract. We call those the vitiating factors. Examples of those are misrepresentation, mistake, undue influence, unconscionable transactions, and duress. And we will talk about those in more depth then. Finally, again, in 4 weeks' time, we'll talk about discharge. That is how do contracts come to an end. So we've got this thing in law, this exchange of promises at law that has legal backing. How do we end this? How do we discharge our obligations under this contract? Which can either be the most common one, do what you said you're going to do, or if you don't and there's some form of breach. In other words, can the other side seek some form of compensation? And we as business students care about compensation because that's fundamentally what this thing's grounded in. We care about dollars. And so this particular week, we're going to be talking about just contracts in terms of them coming together. It's the formation part. All right. A couple of things to note. The very, very first thing, and this is a pretty straightforward concept, you guys are aware probably that contracts can be in writing, but they can also be oral. You can have oral contracts, arrangements between people, and you can have contracts that are a mix of the two. You can also have contracts that are actually implied, so that things where there hasn't been oral conversations, but the conduct between the parties has happened, usually through things like a course of business dealings. We have the same contractual arrangement for multiple months in a row. It can be implied through the conduct that there was a contract here, even though we didn't formally come either in writing or orally to do that. That's the first thing to note. Second thing to note, some contracts must be in writing. What is an example of a contract that must be in writing? Renting? Yeah, rental agreements must be in writing, yes. All contracts for land have to be, or relating to land have to be in writing. Contracts for insurance, guarantees, a lot of marine contracts, contracts for I'm not sure whether contracts for transferring motor vehicles actually have to be in writing. Motor vehicle, yeah, to transfer registration, but you can also transfer literally the physical car at common law, assuming with no registration things on it. You can actually go and do that in it. But the key thing to note, the key thing to take away from writing, contracts in writing, by and large, are just much safer. So when you're having commercial transactions, you almost always want to reduce your agreement to writing in order for it to be interpreted. Because at the end of the day, all of the stuff we're learning is not about when things are all happy. We're absolutely happy. Jacqueline and I, she's got a boat. I've got $10,000. She wants $10,000. I want a boat. We swap. We're done. We walk away. We never have to see each other ever again. All right, and that's fine. But that's a trivial example. This is when things go wrong. And that's why for these sorts of subjects, we talk about things. We talk about this need to go and put things in writing. And when things are put in writing, there are some specific rules that go with that as well. And again, we'll talk about those in a bit more depth soon. So, going through these elements of a contract. Now, to be honest, in terms of real-world legal practice, the elements of a contract are actually very, very rarely in dispute. Okay? If parties come together and they do create some form of contract, the fact that they did create it isn't really usually the issue. Usually it's to do with some sort of defect, so the vitiating factors that we'll do in 2 weeks' time. It's to do with the terms of the contract and interpreting those, because different people might read the contract differently. And it's in terms of breach, people not doing what they say they're going to do. Those are really the main practical legal challenges. So we do have to spend a bit of time talking about creating a contract, but just appreciate that in practice, this isn't really the main area where it pops up in the law. Occasionally, and there is some cases, but they're pretty rare. The key thing to note, though, is that all contracts must have all of these things. 5 out of 7 is not good enough. The term elements is used by legal people. I'm not sure whether it's a legal discipline thing, I'm not sure, but it was never really explained to us. They are conjunctive. Occasionally you'll hear me use the term limbs. Limbs are the same things. It's a series of points, but they are disjunctive. In other words, only one needs to be proved. Here, all 7 of these things would need to be proved in order for a contract to actually exist. So I'm going to go through these one at a time. They, the order's pretty reasonably straightforward. So, first things first, the term offer, very unfortunately, is both used as a verb. So I offer to sell something, or I offer to enter into a contract with you. But it's also the offer, so it's also used as a noun. And that is this clear, unambiguous statements of terms that I, as the person doing the offer, are saying that I wish to be bound on. That's this key thing. An offer is a clear statement of terms that I, as the person giving it to the other side, am saying, these are the things I want to enter into this arrangement and the things that I wish to be bound by. I wish to enter an arrangement by these particular terms. Now, it's not uncommon, by the way, they'll have the case citations here to act as a source. Now, for some of your later pieces of assessment, you will be required to use citations for things. One of the nice things about law, you don't have to necessarily do a lot of research, in that if there is a clear a clear statement of a particular legal principle from a case, just use that case. The ones that I'll try and use here are generally cases from the Australian High Court. They bind all courts in Australia, and so in terms of demonstrating or understanding what a particular rule or principle is, often you can just grab them from the slides to back up what you're saying. It's a little bit tricky when you're copying and pasting the words. This is one of those hard thing, again, particularly people come from a different education system, because the fact that I've written these out in a certain way doesn't strictly mean it's the best way of explaining something. Reasonable people can disagree on that. And when you're trying to explain a legal rule or principle, use your own words and your own understanding of it as well. Okay, and that should be, it should be a bit different here and there. So just leave that in the back of your mind. Okay, so this is the first thing to note about contracts. An offer has to be made by one side to the other. And contract law is, because it flows from this judge-made common law, contract law can be a little bit tricky because we're not going through statutes. I spent all of the last 2 weekends teaching trust accounting, and I was literally going through the trust accounting, the Legal Profession Act, and legal profession regulations. Is the most dull thing in the world. This regulation says you've got to have these things, and that regulation you've got to have those things. It's just statute-based. These rules are a little bit trickier because it's judge-made law. It doesn't make it any less valid, but it does make it a little bit trickier to follow, because when I'm making an assertion of something, and a lot of these flow from Steve's textbook, it's backed up not by a particular act of parliament in a particular section, it's backed up by what the judges have said. And sometimes these cases can be old. I think today, actually, we talk about Pennell's case, one that goes all the way back to 1600s. Okay. And, unfortunately, I can make a statement, a broad statement of legal principle. An offer is a statement of terms that I wish to be bound by. There are lots of sub-rules. And unfortunately, a lot of these you're going to have to know. This is where these things can be a little bit tricky, because this sort of stuff is the stuff over the course of your professional life will come up. I'll say that again. So while learning this area broadly is fine, and it's good, you hopefully will know by the end of this class about the 7 things to do, core functions of contract law. Just make note, all these small little rules are actually part of the law of contract, and they will come up from time to time in your life. I swear this will just come up, 10, 15 years from now. You're like, oh, I remember Simon raving his arms and talking about puff, which is a technical legal term. It sounds a silly legal term, but it is. But these rules will come up, and I wholeheartedly recommend, if you are in business, you are making decisions and you're making particularly strategic analysis of contracts that come in, or arrangements that you're about to enter into, if these things do pop up in your mind, go back and recheck it. Actually go back and have a think about it, about what happened. And if, you know, particularly if you're in a largish organization, call your legal people, get them to do it. Because CYA and all that. So it's not, yeah, most of us, we're doing accounting stuff, not our job to analyze legal stuff. That's someone else's job. Okay, first thing to know, offers can be made to the world. In the case of, in a lot of these common law cases that have stories associated with them, which can be quite sweet. It's actually quite a sweet thing, because you'll remember these stories forever and a day. Smoke ball. Mrs. Carlyle bought, in the 1800s, bought some smoke ball products. And these were advertised in this ad that said, we, the Carbolic Smoke Ball Company, have set aside £500. And any person who buys our product and then still gets the flu, we will give them £100. And so Mrs. Carlyle bought this product. Guess what happened? Got the flu. Guess what she went to do? Where's my £100? And they said, no, that's not a contractual offer. And the court said, actually it is. You've specifically set the stuff aside, make a deal to every person. Any person who buys your product can be considered to be accepting the terms of that contract. You have made an offer to the world. So contracts can be made to all and sundry. They don't, strictly speaking, have to be addressed to one particular person. It must be very clear how a party is supposed to accept that contractual offer. And in terms of the Carlyle, the smoke ball case, they said you accepted it. She accepted it by purchasing it and using it. That's how she accepted that particular offer. Okay. It's pretty rare that you offer things to the whole world. And again, from business perspective, if anybody who goes ever financial controllers and you're asking somebody, should we make this an offer to the world? You go, no, that is the stupidest thing. Don't you remember stage 1 contract law and that silly smoke ball case? Okay, next thing to note though, and this is something that I think we can relate back to our own lives. If you walk past a shop window and there is a sign that says, well, what do we want to buy? Switchblade. We want to buy a knife. Oh wow, this is a knife. Oh wow, $10. Picking up the knife and say, all right, I accept that offer, take the $10, put it on the counter and walk away. Can you do that? Strictly speaking, no. Because in contract law, an advertisement, so a particular product or service advertised for a particular price, is only what we call an invitation to treat. It is not a contractual offer. What it is doing is tempting you, enticing you to go inside, pick the particular product up, go to the counter, and you are the person that makes the offer. Okay, so we can relate to that in terms of the supermarket. When we go to the IGA, IGA is probably a good example. When we look at something on the shelf, that's not an offer. When we look at the price next to it, that's not an offer. When we go, take it to the cashier, we'll say to the cashier, we'll come back to the self-serve ones later. Take it to the cashier. They are accepting your offer to purchase this based on that amount. And that's it. We also call those contemporaneous contracts too, because strictly speaking, they're actually only accepting it at the point where you're tendering payment, which if you've got a card, is the point when the money actually comes through. When the money's come through, yes, we accept that. And the contract comes into existence and at that particular point in time. So just make note. And so this Boots Chemist was exactly that. It was a product in a window. Fisher and Bell. Oh, there we go. There's the other guys. Fisher and Bell was the switch knife, where there was a knife in the window, and some guy said, "Yeah, I'll buy that." And they're like, "No, it was a mistake. It wasn't actually that amount."
Is the law different in the US?
Yeah, probably. And the US varies by jurisdiction as well.
Yeah, because there was a case I went to buy a marine GPS.
Yeah.
And I walked into a store to see what they had, and they had it marked incorrectly.
Yeah.
$100 less than it should be.
Yeah.
And they were trying to sell it to me at that price.
That'll be state law. That'll be state.
And that falls
consumer law.
under, I think it was a case dealing with false advertising.
Oh, okay.
Because
Yeah.
people would put a price on something, get
Yeah.
people in, and then say, no, that's not the
They
price.
call that bait advertising, and that is, we do have the equivalent laws here, and it's governed by statute, and we will actually do it. Even though I put 4 weeks on that little pie chart before, the 5th week we'll talk about consumer law, because we do have rules for bait advertising here as well. Because it's quite a nasty tactic, isn't it? Harvey Norman, oh, we've got all these deals, you know, TV's going for $10, and you arrive and there were only 2 TVs at $10, and now you're there and you're really angry. And so that's it, they do that. But just the default rules, and appreciate that just by the way our legal system works, judge-made law is always trumped by the clearly expressed will of Parliament. So all of these judge-made common law rules, if Parliament comes along and says, if you have a sign in the window, that's considered to be an offer, or you have to sell at that price, they can do that. Australian consumer law, for example, does have all sorts of guarantees. In fact, a lot of areas of law sit over the top of contract law. So if you could appreciate the sale of land, for example, the rule that says all contracts for the sale of land have to be in writing comes from this thing called the Statute of Frauds. It's like 700 years old. So you had to be able to have contracts in writing for there. And that sits over the top. So all of these rules are still there, but they're modified by what Parliament said. So that's just something to note. He said we'll specifically go through and do the consumer law stuff in a few weeks' time. Okay. Another thing to note is this last one. Steve usually plays the video. I'm not going to play the video because it's a bit long. There was I'll explain it though. It was an American TV commercial in the mid-90s that said if you had Pepsi Cola tops, if you got 10,000, like 1,000 bottle tops from your Pepsi Cola bottles, you could pay a small fee, $25, and get an aviator jacket. Or if you had 100 tops, you could get a pair of cool sunglasses. And in the ad, they had, if you collect 10 million bottle tops, you can get Harrier jet. And the ad's like this kid going, whoa, and this Harrier jet like lands there. And so anyway, guess how this story panned out? Some guy worked out that you could purchase the points if you were short. So you could just purchase them for 10 cents a thing. And he worked out, oh, hang on, 10 million points for a Harrier jet, that's only $1 million for a Harrier jet. And so he got a consortium of people to fund him to go and do this. And this went all the way, not to the Supreme Court, but it went to one of the appellate courts in the US. And they said, this is an exaggerated claim or statement designed to differentiate a product. It is not part of the contractual offer. All right, so that's something to note. And it's tricky because the more far-fetched and silly the thing that might look like an offer is, the less likely it is to be considered an offer. So if you are making a claim, and this is going back to that Carlisle smokeball case, the trouble was they tried to argue also that it was puff. Oh, no one would ever give out £100 for if a product didn't work. And they said, well, you actually did go and put £500 into this vault. You actually did go through and take those steps, and you had some aspect of solemnness while you were doing that. And we're not going to accept that's puff. You actually intended for that to be part of the offer itself. So there you go. So the guy didn't get his Harrier jet, as you can imagine. He got a lifetime supply of Pepsi Cola or some lame thing like that. Okay, move on from that. All right. A couple of other things. Auctions. When you bid on an auction, you are making an offer. And the auctioneer accepts that at the fall of the hammer. You guys know what I mean by that? When the auction ends, sold to the lady over there with the purple jacket. Sorry, not Jan. But that's the key thing with auctions, is that each thing you make on it is an offer, but you're not accepting anything at any point in time. All right? So if the auctioneer just pulls out, no, didn't meet reserve, that's not a contract. And so it's call for bids is not an offer. Call for tenders is not an offer either. Hey, do you guys know what a tender is? Tender is in commercial practice. You guys might be involved in this at some stage. A tender is where you have usually quite a large project that you want done. You put an ad out to all and sundry that says, we would like all the local engineering firms to put in an offer. All right, and so the argument here that came up in this Blackpool case, because the engineering company was like, well, you know, we presumed when you did that you would accept the best bid, you know, the best tender, and the court said no. Calling and asking people to make tenders is calling people in the wider community for them to make offers. It's much like the previous slide with Fisher & Bell, Boots Pharmaceutical. It's asking people to come to you to make the offers, and then you, as the person who put the ad out or called for tenders, you then choose to accept the one that you want to. Okay, this rule is actually pretty important, this next rule here. Really, it's actually, yeah, I think it's just in commercial practice. Okay, so I'll say this a couple of times. If somebody makes you an offer, right? Say, sorry, Jean. We're gonna. Is it Jean? How do I pronounce it? Just straight up Jean. It's not two syllables. Sorry. Okay, Jean and I have got a deal. So again, we'll go back to the boat. Jean's got a boat. I've got $10,000. If I say to you, I will buy your boat for $10,000. That's a clear, unambiguous statement of terms that I'm offering to be bound by. All right? If you say to me, yep, done. That's the contract is formed. You've accepted the offer. But if you turn around to me and say, I'll do it, I'll sell you my boat for $11,000. Okay? That is what's called a counter offer. And the really important thing to note is that from that point, Jean is the person offering to me to be bound on those particular terms, and she can no longer, at law, accept my original offer. I'll say that again. If I offer to purchase something for a certain amount, and Jean makes a counter offer to that, that negates the original offer I made. She's making an offer. I'm in a position where I can either accept or reject that. But the key thing to note, and this came up with a hide and wrench, is that you can't go back afterwards after they say, no, I don't want to do it for $11,000. She can't turn around and say, oh, that's fine. $10,000 is fine. Here's the boat. At that point, I can say, no, that original offer I made was rejected, negated by the counter offer coming back. Okay, that's an important. That is actually a rule. So just make note of that when you're exchanging things, particularly with things like email or you're negotiating stuff. If there's a time delay between things, particularly if there's a time delay between things, and the price of what you're buying has changed. So that's the sort of thing that's the sort of stuff that ends up getting assessed, by the way. So it's the your test and so on. But there is a difference between an offer and a counter offer and what's called a cross offer. That is where we both at the same time offer to do things at the same time, and that is two separate and distinct offers, each of which is capable of being accepted. So if I send Jean an email saying I want to buy your boat for $10,000, she sends me an email at the same time, I want to sell you my boat, I'll sell you my boat for $11,000. Those are both in existence, and each is capable of being accepted by the other side. And again, if I accept it for the 10, it comes out to who wins in that one there in terms of who accepts it first. Yep, I accept the boat. The contract comes into formation at that particular point in time. All right, so if you've made an offer and then you don't want to do it anymore, there are mechanisms for offers to lapse. First thing is you expressly revoke it. Oh, I made that offer, didn't buy $10,000, don't want to do it anymore. Provided that's communicated before they've accepted it. If they've already accepted the offer, too late. Contract law, going back to the rules of ye old England, is pretty harsh like that. It's pretty harsh. Once you've accepted an offer and demonstrated that you've accepted it, there's no takesy-backsies in contract law, although ironically, I'm going to tell the story. A very good friend of mine was teaching the stage 1 contract law subject, and she got given her employment contract, and then the woman, the then head of school who teaches contract as well, actually said, I've made a mistake. Can I take some tutoring hours back off that to balance the budget? And so Mel's just like, oh yeah, fine, okay. So Turns out in JCU contract law, maybe there is taxi backsies. What are we going to do? Complain to the union? Okay, that's the first thing. So you revoke the offer. That is the offeror saying, I don't want to do this anymore. And you've got to do that before they've accepted it. The other side's accepted it. That's pretty straightforward. It can be rejected. No, don't want it. So if Jean just says, no, I don't want to sell at that amount. Whether she counter-offers or not isn't relevant. If you clearly express she doesn't want to do it, doesn't want to be bound by that, that's fine. My offer ends at that particular point. I can say, oh, look, I'll leave this open for a week. All right, but usually that's in that situation, the thing comes to an end. Time. An offer which is open, you can specify a length of time. If you don't specify a length of time an offer is open, it is open for a reasonable length of time. You will hear me use that phrase, reasonable, and you will find any person involved in law from time to time gets asked to define that. Judges are very squeamish about describing that term. It is actually up to you in your mind to think about what reasonable is. And you can imagine we all have different numbers. I think what's a reasonable length of time? And in terms of actually cancelling it within this reasonable, it actually depends what it is you're selling. If you're selling a truckload of ice creams, you can imagine the offer is not going to be open for very long. Well, these things, the perishables, for example, that would just be silly. But if, for example, you want to purchase a neighbouring farm and you've known the people for 3 generations, here's an offer. All right, I'll leave it with you. What's a reasonable length of time? Day, 2 days, 10 days, a year? When we think about these reasonable or reasonable person tests, we call them objective tests, and they are for the jury. Now, we don't have jury for contract law matters, so it's usually just the judge sitting alone, but those are what's called issues of fact. They can't be appealed. So just make note, this idea of a reasonable length of time, it's up to you guys. And 2 people will almost always disagree. Those are the things that often have to end up trotting off to some third party in order to resolve. Change in circumstances. Yeah, Jean, I'd like to buy your boat for $10,000, and a day later the boat gets stolen before you've accepted that offer. That's a change in circumstances. That offer is just at law going to be considered void. There's a significant change in circumstances when that happens. Failure of a condition, you can have what's called a conditional offer. What's an example of that? I would like to buy your house, provided I can get finance. If I can't get finance, that offer disappears at law. Usually that's structured into the offer itself. Well, it has to be, because you're establishing what the particular precondition is in order for that particular offer to be capable of being accepted. Incapacity, contract law is actually pretty harsh. It actually is one of these areas where often people with low cognitive function can still enter into contracts. Something to just be a little bit mindful of. Yeah, sure, there are other protections. You can't just go around contracting with people with systemic intellectual disabilities, but we have other aspects of law we use to do this. Because by and large, you are actually held to your actions in contract law. It's a very high bar. And so when they talk about incapacity, that's, if you went into a coma, offered something to do some sort of personal service, can't be accepted if the person doing it has no capability of fulfilling any formal part of those functions. Bit of judicial decisions on that. Personal services, that's usually a thing, but if it was me in terms of selling something, my incapacity after making the offer won't affect that at all. So just make note, that'll carry on. And the same thing with death. Death, by and large, if you have a contract with somebody, or you make an offer, and the other side goes to accept it, but you die before that, if it's for personal services, clearly you can't fulfill them, so that will revoke the offer. But again, other things will be carried on by the executor of your estate. That offer is still considered to be in existence. So that's a couple of rules there to do with offering. So this is the first one, first of 7. Next thing you've got to look at is accepting an offer. Contractual acceptance, and this is the key takeaway from this. You have to accept the terms that are offered to you without modification. That's a really important part. If there's modification, what's that known as? Counteroffer. And it's negated the original offer, and you've now said, these are the new terms. All right, so it has to be without modification. And these rules for accepting contracts, again, there's a few little gotchas. First of all, you can accept a contract in a variety of different ways. Sometimes through a course of dealings, you can have these contracts that can continue on, because through our conduct we've done that. But the person offering the contract can say the specific mode that thing has to be accepted, in which case it has to be accepted through that mode. You must accept this contract by posting this thing back within 7 days, for example. Or with most contracts, when you go to the stores, you will accept this contract by tendering some money out of your bank account and putting it in ours with your little pay wave. And just note silence. If you can't go to somebody, offer them something and say, if you don't reply within 7 days, we'll consider that, that you do want to sell it. I'm like, no, that's not how contract law works. Silence is not sufficient. I've got to teach this. I don't like this rule. I don't like this. Okay, I had to learn this when I was a young fella in my teenage years, when I did legal studies, then again in business in stage 1, and then again when I did contract law and a law degree. I've had to learn this like many times. I've had to teach it many times. I hate this rule. It is a dumb rule. It goes like this. In ye olden days, if a contract was capable of being accepted by post, the point in time that it's considered accepted, in other words, the point in time the contract comes into existence, is when the letter of acceptance is put in the mail. Okay, this is a rule of convenience, by the way, in the olden days. And so you could imagine this, to us now, in this day of SMS and email, just seems really silly. But that was the rule, and it is still the rule. You can accept contracts by mail. It doesn't apply to contemporary technology. That Antares and Miles Far East company, that was a telex. I don't even know what a telex is. Some sort of tappy Morse code translating machine. I'm not sure quite how that works, but they said in that situation that wasn't, the postal acceptance rule doesn't apply to that sort of technology, thankfully. And same with facsimiles, and the same with email. Email is actually governed by its own special rules in the Electronic Communications Act, and it has actually just changed in 2013. The idea being, when you send somebody a contractual offer, the point in time that the contract comes into existence is when the acceptance of that offer gets back into the information system of the original offeror. So again, with Jane with the boat, I send you an email, I want to buy your boat for $10,000. I type the email up, my mail client or web client or whatever, that goes into my, we'll say, Exchange. Exchange goes through to the Exchange server. Exchange server goes to the cloud. Cloud goes to their mail server. Their mail server goes to your email client. When you presumably read it and click on accept, that then goes all the way back again through the cloud. When it comes back to my email server and it's capable of being retrieved, that's the point in time where an electronic contract comes into action, comes into existence. It's a little bit curious as a rule, but they had to pick a point, much like the postal acceptance rule. We have to make it the same for all contracts, because the key thing with contractual offers that are sent off that you don't see what happens to them, or sending them by post, you have no idea until you've got the thing back and you've read it that they've actually accepted it. You don't actually have positive notice of that, but from their perspective, or from when the contract comes into existence, we have to pick a point in time. Postal acceptance rule, when the thing goes into the post from their end. That's just the rule. I hate throwing my hands up in the air and just going, that's just the law. I don't like this rule. I have to teach it. I don't like assessing on it. I think there might be a question in your test, maybe. There's a little pool of questions, so there's a vague chance that this will come up.
Do you think
Yep.
it might be, there's stuff that's come up, they date it from when it's sent because it can actually, it goes to the office.
It's got stamped. It's got stamped. Yeah, I suspect that's so.
Documented in
Yeah.
a federal agent. Post office is generally federal.
Yeah, that's true. Possibly.
It's been stamped and dated.
There is that aspect of parole or evidence where we've got things in writing that can be demonstrated. So when the thing's trot off back to court, if you don't have any sort of thing in terms of stamping, that it's basically he said, she said. And that's why. So possibly it could be deliberate evidence, although it's the point in time the thing is put into the box, which might not be cleared for a period of time too. So you've still got that drama too, but I'm not sure.
Maybe the law came around at a point before.
Yeah, possibly. Yeah, that's a long time. I don't know much. My knowledge of the postal system in ye old Britain's a little bit poor, I have to say. I'll add that to my spiel next year. Okay, a couple of things to note. Offer and acceptance can be contemporaneous. A good example of this is buying your groceries. They are not going to, you are, strictly speaking, you're offering to purchase them. They're not going to accept that offer until the money's come. You ain't walking out of there with those groceries. No contract comes into existence. And that's why you can't say, oh, the machine's broken, guess it's free. Anyone's ever worked at retail? That's not funny the first time you hear it, and it's not funny about the 800th time. So just make note, the contract for those things are contemporaneous. That comes into existence when when things form. Offer and acceptance happen at the same time, when money transfers. Okay, there you go. And the stipulated method of acceptance can be payment. This contract, I offer to do this. You accept this by paying me. Seems pretty fair. The contract happens at that particular point, comes into existence. That doesn't mean, though, that both sides' obligations are discharged at that point. Because usually payment means that one side, when we go to the store, one side's obligations have ceased. I've paid IGA. Do their obligations cease at that point? Strictly speaking, no. If, for example, the product is defective in some way, I get home and find it's mold, they've still got obligations, both at common law and at Australian consumer law. Okay, partially accepting an offer. So I'm doing some little bits, little preliminary steps to demonstrate that you have accepted an offer isn't actually determinative of you actually accepting it. So here, this I think was a development of a oil terminal or something. No, sorry, that was petrol stations. Petrol stations actually going and taking steps, for example, to refurbish the petrol station, all right, isn't actually a clear demonstration that they've accepted the offer to renew the lease on certain terms. All right, so just notice that. Make sure, the key takeaway from this is to make sure that you're clear and unambiguously accepting offers. What's a really good way of demonstrating that you've accepted a contract in writing? Signature. That's that point. And there's a couple of quite cool things involving signatures that we need to learn about. They're quite cool, they're quite horrible, but we'll go, that's next week. Okay, competed standing forms. All right, so if I'm the seller, Jean's the buyer, and we've got, we have our company, each of them has standard forms, me for selling, you for buying, all right? If those two standard form documents don't line up, that's a bit of a problem. I filled in my, you've signed my standard form selling form, and I've signed your standard form buying form. The law, sometimes these cases can be quite hilarious because they may not line up. It may say title passes when you deliver, the other one may say title passes to the goods straight away. All right, or we're not going to pay until everything's been completed, or after 4 months, or whatever have you. And so the idea is that, strictly speaking, those two forms are actually two contracts, and it's up for the courts to determine usually which was the actual contract that they were working on. They don't try and mix and match the two. They will try and work out which was the actual contract that the two parties were operating under. Okay, they're cross offers, each capable of being accepted. That can happen time to time. That's something to leave in the back of your mind. All right. Yeah, right. Offering, okay. Contemporaneous means at the same time. Some contracts, for example, when you go to IGA to buy food, the offer and the acceptance of the offer happen at the exact same time. I'm offering money, and the way I'm offering it is putting my card in the machine, putting it into your bank account. At that point in time, they accept this contract to be bound for the purchase of these goods for that amount. That's really this key thing. A lot of contracts are like that, where just literally we come together at the same time, we all agree on a set of terms. Sometimes you thrash them out. You sit for an afternoon and thrash out the terms. Or sometimes, and again, I had this hilariously for the purchase of our property around the corner, the real estate agent drafted the contract for sale of land, and I had to go backwards. He had sent it to me, and it had all of these errors. So I corrected a bunch of errors, sent it back, and it bounced backwards and forwards 9 times. So trying to work out exactly which one we used in terms of sending it to them, it was a little bit complex in terms of the timing. But many contracts we have, the offer acceptance and the entire performance can happen at the same time. All right, that's acceptance. Next element is this thing called consideration. This is a little bit tricky. When I talked about ye olde England, how contract is fundamentally about this exchange of promises. Key thing, oh no, that's not the right, what? No, that's not the right slide. No, got to fix that slide. Ooh. Ugh, ignore that. That's literally a copy and paste of the previous slide. A bit awkward. Consideration is the promise. It is the thing that is flowing from one side to the other side, and both sides must provide something. I'll say that again. The consideration is the promise itself. It's the value of the promise, and it must move from one party to another. Both ways, actually. Both sides have to provide consideration. So again, going back to the boat, my consideration is $10,000. Jean's consideration is a boat. Those are the two things that we promise to exchange. And that is one of the elements of a valid contract. What does that mean? If there is no consideration, so if I say, or Jean says, here's my boat, it's worth $10,000, but you can just have it. That is not a contract. And if I come to pick the boat up the next day, she says, oh no, I changed my mind. Can I enforce that in the courts? No. There's no consideration offered. And this famous case, consideration must be sufficient but need not be adequate. The famous line in contract law is a peppercorn is sufficient consideration. And I'm just going to unpack that a little bit. You guys know what a peppercorn is? You know when you have pepper and you just grind up the little black things like that big. What that means is that the courts of ye olde England at common law do not care how fair the deal is. They don't care on the face of it. If we, as two rational people, come together and have a meeting of minds without defects in our mind, not under duress, not under some mistake or misrepresentation, if we as two economic beings, think of economics, this pure abstract individual, self-interested, utility maximizing individual, we come together, we're exchanging things. The only reason you're going to do this is that you're going to be better off through having this thing and I'm going to be better off through having your thing. We swap those things, we're both better off. And we repeat this process many times. Again, the courts therefore don't care about some abstract value of things. A peppercorn is sufficient consideration. Common law. This goes against the grain of many of the other systems. The Chinese system, the Confucian-based, the traditional Chinese system, the Islamic system, and some of the codified ones as well, like socialist and so on like that. So just make note, the system that flowed from the British common law does not care how fair the transaction is. That's the starting point. Peppercorn is sufficient consideration. But illusory consideration is not valid. What does that mean? It means something that you are offering that you could never actually fulfill. For example, it is sufficient consideration for me to offer to somebody to not light fireworks in the backyard of my house. All right? It is illusory consideration for me to say, I will not launch a spaceship from the back of my yard. Why? Because there's no conceivable or possible way that that could ever happen. There's no possible or conceivable way that that could ever happen. I can't promise to not stand one-legged on the moons of Mars next week. All right, that's what they call illusory consideration. This can be a little bit tricky to get conceptually, because unfortunately consideration is probably the hardest part, and possibly the most important part actually of this part of the course. And another thing just flowing from that is that, so illusory consideration that you could never actually fulfill anyway. In no conceivable world could that happen isn't consideration, but also past consideration. So again, if I mowed Jean's lawns last week because I'm just the swell guy, right? We can't have a contract now where she'll give me $100 for mowing her lawns that I did last week. I've already done that. And at the time, we didn't contemplate there being a contract. It's past consideration. It's something you've already done, and you didn't contemplate this forming part of a contract. Jean can give me $100, but it's not a contract. No consideration is passing, because past consideration is not valid. Example here, Stilk and Merrick. Past consideration of a pre-existing contractual duty is not good consideration. Stilk and Merrick was this horrible case where a sailor was contracted to sail from Portsmouth, somewhere in England, to the Caribbean and back again. And it was a whole of trip contract. You do the whole trip, you work on the boat. Oh, no, sorry, no. Nope, I'll take that back. No, that's not Stilk and Merrick. No, this is an even better case. No, this is a better case. This was a case involving a boat from India, actually, going to England. A lot of these things, by the way, these cases involve coming to and from Britain in boats. So this one was coming from India. And what happened was the crew, were averagely paid. When they got to South Africa, though, they got to the Cape and they went ashore, bit of boozing, and a whole bunch of the crew deserted. And so what the captain said is, to all of the crew that said, if you guys stay on, we'll pay you £10 extra when you get back to England. What's the problem? They were already under an existing practical, pre-existing contractual duty to do the whole voyage. What are they providing to get this £10? Nothing. Nothing. They've already, that consideration is already, they're already under an existing duty. It is not valid consideration. All right, that's the next thing. The next thing here is, I think this is the oldest case we do. This is good law. Pennell's case is still good law, and it actually might come up in your assessment. Not this one, but maybe in the next one. It goes like this. Partial payment of a debt is never good consideration for a contract to release a person of the whole debt. And this really goes back to the psyche of ye old England, doesn't it? If you've got a debt of $10,000, say I owe Jean $10,000, I can't say to her, I'll just pay you $8,000 and we're good, right? I mean, I can say that to her, but it's not good consideration. We can't have a contract to release somebody from a smaller amount of debt, from a bigger amount of debt by paying a smaller amount. It is never good consideration. Okay? Yeah, right. They can do. They choose to do that, but they have no contractual obligation to do so. So it's basically, you can't, if a bank says, we're going to waive this debt, and you go, okay, and then they change their mind, it's not a contract. They're still allowed to go and recover that. Banking is also quite heavily regulated as well, to be very, very much by the federal government to make sure they don't do naughty things. And so banks do from time to time waive debts, and they do that under their own banking statutory framework. They're not doing it using the common law rules of contract. Okay, so that's a little bit of brain required here. You're going to need a little bit more brain here as well. Sorry about this. This is to do with consideration. Forgot, by mistake. All right. This bit's a little bit tricky. Why? Remember before, I think yesterday I talked about this murky area of law known as equity. This used to be done by the priests. So you'd have clergy were the ones that dealt with this area. And it only arises where there's some defect in the common law rules. And this high trees, but the Australian position is in this Walton Stores case, basically goes like this. As an exception to this rule of consideration, if you think that there is a contract in place and you go about and start doing things, right? Start doing things, and it's impossible to undo these things. It's possible. So you've spent resources, you've gone and started performing what you think is a contract that turns out there isn't actually a contract. All right? Pardon me. And the other side knows about this and lets you carry on. All right? There's no contract here. Now, remember, if there's for whatever reason there's no contract. Now, usually people do this, by the way, when they're laboring under this thought that there is a contract. And again, Walton Stores was to do with redeveloping a shopping center. And the guys who owned the land worked out that, there was a statutory, and state government actually had a rule that said we couldn't do this. So that we can't do the development at this particular point in time, or there's no particular contract. So anyway, they let the Walton guys come and just build the building. So they just built this whole building. And then they found out later on that the other side had known about it, and it just let them carry on building it for however long. And so that, and again, this area of law is to do with good conscience. Equity is to do with good conscience, to remedy defects in the common law. And there they say that a grave injustice would happen if you followed this strict contractual, the strict common law rules of contract. Because in that situation, there's no particular contract. And so that's what they said in Walton State. And that is essentially, it's an exception to the rules of consideration. It sort of falls under that area. We will actually come back to this, that High Trees case we'll come back to a little bit later. Another one comes up, this Commonwealth in Verwayan. Do you know Australia used to have an aircraft carrier? It's kind of hilarious when I say that out loud. It was an old, I think ex-World War II, or ex-British, 1950s aircraft carrier. Anyway, it had one night in I think it was in the 60s, it had a crash, a really bad crash. So the Australian aircraft carrier crashed into this destroyer, and a lot of people died. And what happened, and this went all the way to the High Court, is that the government had said, you can sue for these injuries. It's going to take a long time to sort this out. We're just going to ignore the regular limitation of action rules. And then later on, what did they try and do? The government changed, and they're like, no, we don't want to pay this. No, that was the previous government. That wasn't us. And went all the way to the High Court, and the High Court said, no, you cannot rely. Sorry. Strictly speaking, the common law, they're right. State government's right. Yes, they don't have to pay this, but it's going to create a grave injustice. So much so, we in equity are not going to allow them to be able to rely on their strict common law rights in this situation. That's look, it's going to be a little clear as mud. We actually revisit the High Trees case a little bit later on. So just in the interest of time, I'm going to move on from that. This is going to be, I'm probably going to have to re-explain that at a later stage. One thing I do just want to mention though, as another exception to consideration, what's called deeds. A deed is a document. Thank you. Okay, a deed is a special type of document where Parliament, the Queensland Parliament, a long time ago, in the 1800s, created a statute and that said, you can create a special solemn document that you sign and seal, get stamped, has to be witnessed by a legal practitioner and signed by a JP. And this deed lets you bypass consideration. I'll say that again. You can have a special document for contracts that have to be co-signed by JP, has to be stamped by JP, it has to be witnessed by another person, but it allows you to bypass consideration. Why would you do that? Going back to this idea of the boat, if you actually genuinely did want to transfer your house to your son's or daughter's name. All right, people can do this. But it has to be, as you can imagine, a very solemn, very clear, and the legal practice we're obliged in JPs to say, are you under any form of influence? Is there anything improvident that's happening here? Tell us, they're allowed to go and inquire in regards to these things. Okay, so just make note, a deed is a document, a special document. It's quite a very, very high bar in terms of doing these things. And other forms of law use this. You see guarantees, for example, because if you think about it, a guarantee, if your kids, say one of your children is going to buy a house, and they say, go to you and say, we would like you to guarantee that, what do you get out of that? Nothing. Nothing at all. It has to be done by deed because the other side's not offering any consideration at all to you to guarantee that happening. And there's a couple of other deeds as well. Indemnity. If you have a cause of action, say for example, you're about to sue somebody and they agree to settle, the most common mechanism you use in order to resolve that is that the side who's bringing the action enters into a deed, what we call a deed of release, where we say, we will no longer sue you. Here's a document. You can put this to the court. We will no longer sue you. We are considered bound by this. And when we give this to you, you will give us $10,000 or whatever the amount is. So strictly speaking, it's essentially two considerationless contracts. They're going and exchanging those things. All right, next slide. This is the next element. Intention or intention to create legal relations between the parties. Can you enter into a contract to buy a house off your mum? Well, if you'd asked me this question when I studied law in the 90s, I'd say, no, that's ridiculous. And for a long time, and again, you'll probably find in this book here, it's a long time the Australian courts had followed the British rules, British systems on doing this. And the default rule is things involving family members, not a contract. You don't have the requisite intention to be legally bound by default. All right, and that's flipped around for commercial arrangements. All right, if there's a commercial arrangement, by default, you are considered to be legally bound. You are considered, when you're entering into that transaction, to be intending to form legal relations. It's not just a bit of silliness or something we didn't really intend to go to the courts about. Now, what could be a problem here? Well, what if you enter into a commercial arrangement, what if you enter into a lease for your brother-in-law's shop? Is that family or is that commercial? And so what the court said in this homogenous and Greek Orthodox community case, and they said, look, it's really just a matter of degree. In every given situation, yeah, sure, the old rules by default, it's this, that thing, really, they don't really apply much anymore. We're not going to have presumptions that it's family, it's not intended to be contractual, and non-family it's not. We don't think that's appropriate anymore. We're just going to say it's going to be a matter of question and fact and degree in every single case. Generally, if it's got commercial overtones, it's a contract. You're intended to be bound. And if it's family, it's not. So Balfour and Balfour was a case involving a mum who wanted the daughter, I think, to go back and study something serious. So paid her some money or some stipulation or promised to pay her money in order to go, go this, come back to England and come and do something serious with your life, do something good with your life. And in that situation, and the daughter goes, after a while, okay, where's money? No, I didn't mean to. No. You're just doing it just because to improve yourself. I was just guiding you. Well, yeah, generally in those situations, it's not a contract. Okay. Yeah. So now you can have these honor clause things as well. Again, you can literally create a document that looks and smells and reads like a contract, but actually has a clause in it say this is not a contract. This is not a contract. Both parties are aware of this. This is just us mapping out what we intend to do, but we don't intend to be bound by the courts. It's a matter of honor. to go through and do what we said you're going to do. You can do that. It's, look, why would you do that? Why would you map things out? Well, family. You're mapping things out. How are we going to go about subdividing this land? Well, how about you go through and do this, and you go through and do that? It's a plan, essentially, rather than a contract. Yeah, going through and doing these things to make things more orderly. But we don't intend to actually take this to court and for it to have legal consequences. Really, that's that key part there. Okay. Capacity. Again, the rules for capacity are pretty high. There's a pretty high bar to argue you don't have capacity to enter into a contract. It's on the next slide. Booze won't get you out of a contract. You're heavily intoxicated, too bad. Tough luck. How sad. There are some situations where capacity does come in. The first one is minors, kids. Now, kids actually, by default, they can't have contracts. All right, but you could think of there could be some situations. What's the age of majority? How old are you legally an adult in the state of Queensland? It's 18. 18 is the state in Queensland. What's the age of full criminal responsibility in Queensland? It's actually just changed. It was up until, I think, the start of this year. I think it might actually be this year it changed. It was until quite recently 17. So your 17th birthday, it was the same in New Zealand too. It was always really sad because when you turn 17, you don't get any rights. You only get the ability to go to the big house if you do something bad. So it's 18. I believe now it's uniform across all jurisdictions in Australia. It was all over the show for when I was studying about 10 years ago. Now, if you are 16 years old, can you leave school? Yeah. Can you get a job? Yeah, you can get a job. You can get a part-time job as a kid. You can do that. You can rent a house. You can buy a car. You can do a whole bunch of these things. It would be pretty poor if both other people can go to you or you can go to other people and say, oh, no, sorry, mate. Sorry about that car that I bought and haven't paid for. I'm actually a minor, so I've taken it and trashed it, and I don't owe you anything because I'm only 16. And so what they say is that, look, by default, minors, contracts can't be enforced against the minor. They get the double chance on this thing here. They can enforce contracts, but they can't enforce them back. But there are some situations where the third party can enforce contracts against a young person, and that is contracts for the necessities of life and beneficial contracts for service. What that means is that if a person is 16 years old and has a job, you can enforce that against them. Now look, in terms of employment, 16-year-olds generally don't make the best employees. And so when you're trying to enforce this contract in the court, you're usually going to be hard out of luck because the way waged work is you come and work and then you get paid. All right? If you've paid them ahead of time and they don't turn up, strictly speaking, you can go to court and at least get your money back for them going through and doing that. That's an exception to this rule against contracts for minors. Good luck trying to get money out of 16-year-olds, but each their own. And necessities of life. What are the necessities of life? This is an old case. This is the sort of thing the legal academics, when teaching this, like, let's turn this into a discussion. Is a smartphone a necessity of life in Australia in the 21st century? Some would argue that it probably is, actually. I think when I would have done contract law at JCU 10 years ago, I would have said no. Now I'd probably say yes. I'd say it pretty much is a necessary component of dealing with a lot of things in the world, going and doing stuff. Shall we put it to the vote? Who reckons a cell phone is a necessity of life? Who reckons it's not? And those teenagers should just harden up and sit around the campfire and read books. All right, so as mentioned before, booze will not get you out of things. Look, it can actually do it if a person is clearly intoxicated when doing it, because you don't have the meeting of minds when doing it. When they can demonstrate that there was clearly and unambiguously no possible way that agreement could have been met in relation to things, but it's pretty hard. What is more pressing for you guys is this idea of incorporated and unincorporated entities. I think I mentioned this last week for you guys. In an incorporated society, incorporated under the Queensland's Associations and Corporation Act 1981, is a legal entity. It can sue and be sued. It has standing in the eyes of the law. and it is separate from its members. All right? It has capacity to enter into contracts. Unincorporated society do not have legal capacity. All right? They do not have, as an independent entity, they are considered at law to be the members collectively. What does that mean? If you're in an unincorporated society and they are buying and selling things, be very, very careful about what and how your membership is structured, because a lot of these things are done jointly. You can end up being jointly responsible for stuff. So leave that in the back of your mind. If you're involved with bodies that are not incorporated but have things like bank accounts and people are going out and buying and selling things, right? Leave that one in the back of your mind, particularly for you guys, accountants. And again, most of you guys aren't from Australia. One of the very, very noticeable cultural things about Australia is the community associations and voluntary groups. This Australia, as a per capita, has many, many, many of these sorts of institutions, and a lot of people do spend time doing volunteer work and getting involved with things. The trouble with you guys, because you're probably going to be chartered accountants at some stage, invariably you'll end up roped into that sort of organization. And hey, you want to be the treasurer? Because that's the one committee role that actually requires technical skills. And guess what? You guys have those skills. So just leave it on the back of your mind. At some stage, you're probably going to be involved with this. You're going to hate it, but it's, you know, it'll be a part of life, particularly if you guys do hang around Australia and you do, you know, if you're here for a long, long time, you'll get involved with these things. Just make note, incorporated societies, unincorporated societies, massive difference legally. Liability problems up the wazoo over here. Okay, bankrupts. Bankrupt people, their contracts are usually with what we call the trustee and bankrupt. Do you guys know what bankrupts are? I'll explain it very, very briefly for those that don't. Bankrupt is when a person is declared by the court to have no assets. All right? You can only do this when a person asks the court to wind someone up, to actually say, no, you are going to be declared bankrupt. And what happens is an independent person is set up to look after what stuff you do have. They're called the trustee in bankruptcy. And the contracts can be made, but it's done through the trustee by default. Bankrupts can go and make things, and usually it's the trustee that has to try and resolve those things. Okay, and also note the same thing applies with liquidated companies. They have the same thing essentially applies where you get a liquidator for a company which is being wound up by the court. Board of directors gets sacked, and it's replaced by a liquidator who steps in. And their job is to try and manage the company, either to liquidate all the assets or to try and bring it back. Oh, they're called receivers or receivership, to try and bring it back into some sort of solvency. Usually it's to wind it up. Okay, and yeah, contracts with the other side can usually be, rescind means to undo, to voluntarily undo a particular contract. I think we're almost there. Oh, how many more slides have we got? Yes, not many slides. All right. Oh yeah, 2 slides. Oh, great. Okay. Mutuality. What this means is that the parties coming together to exchange these promises must actually know what those promises are. That's not to say you've read all of the terms on your Apple iTunes agreement before you scroll to the bottom and click accept. But fundamentally, we have to be talking about the same stuff, the same subject matter here. And it can be a little bit uncertain, it can be a little bit vague. And the example that we use, because this mutuality also comes up with what we call mutual mistake later on. If I'm going to buy, I say to Jane, I want to buy your blue Mitsubishi for $10,000. All right, she says, yeah, sure. And I arrive at her house, and we find that she thought I was meaning the heap of junk Mitsubishi Magna that she had out the front that's rusting away. I thought we were talking about the blue Evo 6 Lancer turbo awesome mobile out the back. All right. we're at cross purposes. We're not talking about the same thing. And we talk about this both when I'll talk about mutual mistake in a few weeks' time, but also actually in forming a contract. If we're not speaking about the same subject matter, it's not a contract as such. Look, in this situation, sometimes only one side can be mistaken. Well, that's tough luck. Again, we'll talk about that when we do officiating factors. But this mutuality in the next slide, which is legality, can be analysed both as elements of a contract, just briefly, but also as what we call officiating factors, ways of getting out of a contract by arguing that we didn't have this meeting of minds. All right, and that last thing here is important, and we'll talk about this when we talk about terms as well. Ambiguity is everywhere. It's everywhere in life, it's everywhere in business, and it's often in your list of contractual terms as well. Now, this term, objective intention, what that means is that there's no point when you're trying to read a contract to try and get in the mind of what I thought it meant and what you thought it meant. There's no point. And the courts say that, look, it's actually not about what either of the parties actually thought that it meant. It's what a reasonable third-party observer looking in on it would think that those particular terms meant. And what they say here, and the reason why mutuality is here, is look, you can have this ambiguity. It's okay. By default, it won't destroy a contract, right? Unless it's so ambiguous that a third party looking in would be like, what the heck is the subject matter here? What are you talking about? It can't be ascertained objectively from this third party looking in on it. In that case, you won't have this element of mutuality. The contract won't form. All right. And on that, this idea of a contract not forming, that's not to say, by the way, that we haven't already swapped the boat over or given the other person money. And appreciate this is a real problem, because if there's no contract and you've got my money and I've got your boat, all right, if there's no contract, it's still your boat and that's still my money. And we have to use areas of law to try and undo these things. And the key thing to note about not satisfying the elements, if all the elements aren't satisfied, there's no contract. This whole arrangement was completely void from the very outset. All right? You have my stuff and I have your stuff. How we go about resolving that is up to us. We can use the mechanics of law, which is I can go and ask the bailiff to get stuff back, or usually what you do is you make a demand on the other party. And when we talk about tort in week 8, we'll talk about this idea of called detinue, which is where something which is lawfully yours, you ask for it back and they don't give it back. You can just sue for a dollar amount. Or sometimes you can actually specifically go and you can actually go and ask the court to get your stuff and do it back. But the key thing to know, if there's no contract, it's still your stuff. And one thing they don't really teach the undergrads, and I know why, but they do teach the barristers, self-help is a real thing. What do I mean by self-help? I've got your boat. What's the easiest way for you to resolve this, to get your boat back? Go in the middle of the night, pick your boat up, and take it away. You probably want to leave the $10,000 there as well, but let's save that for another day. That's really up to you. But if there is no contract and title hasn't passed, and the other person's got your stuff, self-help is still an actual remedy. Going, getting your thing, picking up and doing it. And builders, traders and people, they do this all the time. Hey, you didn't pay me for this. I'm going to take my tiles back again, thanks. Take them away. Grumpily, take my tiles back again. It doesn't mean that they can't still sue for work done and other things in the court. But by default, if there's no contract, it's your stuff. It's not in your possession sometimes, but it's your stuff. When we talk about title, and I mean legal title, that is the true owner of a thing. And sometimes this goes with registration too. So cars, for example, cars, houses, boats, they're all registered to people. Usually when I'm thinking of these sorts of examples, I'm trying, even though boat is the example I'm using, I'm trying not to think of it in terms of registration, because title flows with whoever's name is on the register. And in this day and age where everything's computerized, heaps of things have registers, and the Queensland government maintains that register rigorously. All right, last slide. All right, legality, again, we'll analyze this both as an element of a contract as well as what we call a vitiating factor later, because there's a few more rules we're not going to do now. The key thing to note is that you can't have a contract to kill someone. It sounds dumb when I say that, but just by default, at common law, a contract which is just absolutely overtly criminal is not a contract. All right, you can't go to the court. Now, strictly speaking, though, again, strictly speaking, and they talk about this again when we talk about legality, it's not, with a lot of these things, that it's not even necessarily that it's a contract. It's more that you can't go to the courts to enforce anything that might be under a contract. I'll say that again. It's not, strictly speaking, that contracts in many of these situations are strictly speaking not a contract. What it really means is you can't go to the courts to enforce it. So here, the example, question?
I was going to say, is that like you might have a contract with someone to produce illegal drugs?
Yep. Yeah, that's right.
It might be a legitimate contract, but
you can't go to the courts to do it. And what they'll do, and the reason why we actually go through this in the vitiating factors in more depth, and the reason for that is that some contracts can be illegal as formed. So a contract to kill or a contract to produce methamphetamines is illegal as formed. There's no two-way or way around that. All right. Some contracts can be illegal as performed. Hey, I need you to produce these drugs and these drugs and the, oh, that's probably not a really good example. I need you to produce this substance lawfully and this substance lawfully, and then I want you to mix some of this up and some of this there, or throughout the process of doing it, you've made too much paracetamol or whatever, more than your prescribed limit that you're allowed to make. Now you've got a pumper truck's worth of pseudoephedrine or whatever it is. That is a contract that was formed legally but performed illegally, and it can be complicated because you've got to, the courts have to sort of step back, because generally contracts that are formed legally, hey, you've got a contract to make this much drugs. Oh no, you made this much. Oh no. Strictly speaking, that is a contract. It was legal as formed, even though it was performed. Now it gets even more complex, where, for example, I have a contract for you to courier this mouse down to Brisbane, all right, in your car, and you've got 13 hours to do it. Is that a contract that's, strictly speaking, illegal as formed? What's the only mode that you could do to make that contract actually be performed? By speeding really fast in order to get there to fulfill that. And so you think, well, and it's that sort of analysis, because sure, 13 hours is a bit ridiculous, but what if it was 18 hours, and remember you've got to take regular breaks, and so you've got to, this sort of analysis, this is the stuff that ends up going to court, trying to analyze whether things are legal, illegal purely from the outset, because if it's illegal purely from the outset, there's no contract, and you can't force it in the courts. In fact, there's Everett Williams' famous case. It's probably made up and just reported in a judgment later, but I'll tell you it anyway. So you had two highwaymen that went around robbing carriages in northern England, all right? And so they had a dispute after they robbed something about how the thing was to be done. So they got a lawyer guy, and the lawyer guy suggested that they go to the courts, actually go get the judge to work out how to split this thing up. And so the judge, throughout the civil matter, works out what it is, what actually happened, and then sentences the lawyer to go to jail and the two highwaymen to be hanged. Apparently, it's probably made up, but it's kind of funny. That's Everett and Williams is quoted as there. And also note, that second one there, this Amiago Pastoral, the court bends over backwards to try and uphold the existence of a contract. What they want to do is to say, look, it's far cleaner that a contract exists, and we're going to analyze breach and stuff underneath the terms of it, rather than saying there's no contract and trying to use other principles of, oh no, how much work have you done there already? How much has been paid there? And oh, this is just a mess. So they will try very hard to find that a contract is lawfully formed, even in situations where modes of performance may be unlawful. Because often you find people can form contracts and they don't realize it. Neither side realizes that what they were doing was, strictly speaking, unlawful. Again, crystal meth, the pharmaceutical stuff, you'd expect that you'd go through and know what your amounts are, but maybe they got it wrong. But it's not at all uncommon. We live in a very regulated society. And so it's not at all uncommon to find out what you're doing hasn't been done strictly to the letter of the law. Doesn't render it, by default, not a contract. That's really the key takeaway from that. But you can't make them especially. Oh, yeah. Parliament can jump in and say you can't have contracts for producing methamphetamines, or you can't have contracts for I'm trying to think of it. Oh, hang on, what was that? Exercise. You can't have contracts to further a particular unlawful purpose, or contracts to further immoral purposes. And I talk about this when we do the Officiating Factors. Some contracts, common law, are not lawful. Gambling. If you have a poker evening, even if you write down an agreement, we're going to agree to have a poker night, we're all going to put in $1,000 and we're going to follow the rules of poker. This is the adjudicator, and at the end of the night, we're going to split it according to the rules. You actually can't do that at common law. It's not a statutory rule. Courts will never enforce contracts for gambling. They just don't. How does the casino get away with it? Statute. Queensland Parliament says there is to be a casino in Townsville. There is to be one casino. It is to have this many machines. They are allowed to make this much money. That's how they do it. Because by default, contract at common law, you can't have those sorts of agreements. I promised that this was going to be late, but we've actually finished a bit early. Are you guys happy with that? What I'll do is I'll flick off the recording and we'll take some questions. And if they've, but essentially that's the end of this particular part, this first week on contract law. I hope the story was enlightening, interesting. Not sure what the right word is there. Entertaining.